Hello, everybody. Welcome back to the Schiller Hamilton Podcast. Today we have David Manzi, who's come down from Beaufort to talk with us about Dram shop liability and what that is. And so I have a bunch of questions, but first of all, David, where does the term even come from?
Well, the dram shop, we were talking about basically alcohol use. And dram, the word dram itself was an Old English way of measuring the amount of alcohol that was given to a person, and I believe it's 3/4 of a teaspoon was a dram. And somehow along the way that got picked up as being the term used in the type of liability cases that we're going to talk about today.
So you already kind of mentioned it is about liability. So would you go ahead and kind of explain the difference between what a first-party liability and a third-party liability is in terms of dram shop?
Certainly. It's basically what we consider a third-party liability, which means they weren't directly involved with the negligent act that took place. Let's use as an example. You're struck by a driver. You're driving along, and a driver hits your car, and they're found to be under the influence of alcohol, DUI. So that gives a heightened awareness in terms of the type of claim that you can do, because now you can trace back as to where did that person get the alcohol that made him intoxicated. And if you can trace that back to a business establishment, and then you can trace it to find out that the business establishment knowingly gave him more alcohol than they should, given his condition, we can hold the business establishment liable for his actions. So they're kind of like the third person. They weren't involved in the car accident itself, but they're the ones that help that person, if you will, get intoxicated, which then caused the accident. So that is the most common way that dram shop liability comes into play. There are requirements, though. You have to show and demonstrate that the establishment knowingly continued to give liquor to the person when he appeared obviously intoxicated. And that's usually done through witnesses. Sometimes these establishments have video cameras. I had a case a number of years ago where the person became intoxicated, got into a fight with this elderly gentleman at the establishment, punched him, and actually killed the person. It was a one punch, just happened to hit him in the right spot, and the person fell and hit the ground. We actually had video surveillance that we got from the establishment that showed that this person was obviously intoxicated. Being intoxicated is something that the average person can see. It doesn't take an expert to know when somebody's intoxicated. And we can see on the video that even though this person was obviously intoxicated, the bartenders kept on serving him liquor. We actually can see that. And it wasn't even like he was asking for it almost. They were just kind of bringing it to him and giving it to him. So that was an easy case in terms of proving the liability side, that they gave the alcohol to a knowingly intoxicated person. The other way you can establish liability is if you find out, say the person that struck you when they were intoxicated is under the age of, under the drinking age, is a minor. Well, then you can go back and find out where did they get that liquor from. Mm-hmm. And it's even more than just doing it from a bar or restaurant establishment. You can even go to an ABC store or any store that sold liquor to the minor. Now, they can say, well, we didn't know they were a minor. But a lot of times, again, it's obvious that a person is using a fake ID. And that's why a lot of establishments basically card you if you look like you're under the age of 35.
You're talking about the scan function.
Yeah.
And that's a database that they use to reference. It's a government program?
That I'm not.
You're not too sure?
I'm not sure of. But this normally happens. In fact, take a case where a person goes into a Parker convenience store, a minor, and they purchase a bunch of beer, and the Parker store say doesn't even card them, or is they're obviously a minor and is obviously have what looks like a fake ID, but they sell them the beer anyways, and then that person gets into an accident later on. You can go back and hold Parker's liable for selling the liquor to a minor.
So the fact that they're using a fake ID doesn't affect their liability in that case against the establishment?
Yeah, only to the extent that it wouldn't have been obvious to the person. But again, then you go into training, because you can do in terms of the how did Parker train their employees to be on the lookout for not selling liquor to minors? What steps do they take if they're suspicious about it? Do they err on the side of caution? So there's a lot of aspects you can get into in order to prove the liability aspect of that. And the same holds true for a bar or a restaurant that would serve a minor. They're going to be liable if that minor then gets into an accident and it's shown that the accident was caused by them being intoxicated.
So that's a great point, and I'd love to ask in a more in-depth, who is actually liable? Is it the bar and the bartender and maybe a vendor if it's a contractor, they're at an event? Like, how far does liability go? Is it a lot like trucking accidents where it's kind of horizontal and you have to go to multiple entities to find the liability?
Well, it's pretty sad. In this case, the liability is just going to be with the end seller. The person, whether it's the bartender, and then by
that's what the policy law is.
And then to the owner of the restaurant. The restaurant or the bar is really the person that's going to be responsible. And in the Parker situation, the company Parker's would be responsible for that. Or any convenience store or any kind of liquor store that sold the liquor to a minor, they're going to be responsible to that. And they're the ones that usually have the insurance on that. So that's what you look for.
So far we've only really talked about restaurants and bars, but that's not the only aspect that this can be involved in. Can you talk about how it can be involved socially with just house parties and when there's not an establishment involved?
Right. A social party, I mean, think of any time you have a party at your house. Or even, and actually the social aspect of this arose more from what happened on college campuses at fraternity houses, okay? You have a keg party at your fraternity house, okay? And there was a number of college students who are underage. Just by the nature, most freshmen and sophomores are probably going to be underage. But they come to your fraternity party, and then at your fraternity party, you don't check anybody's ID normally, and you don't do anything. Well, one of those freshmen, leaves your party intoxicated and gets into an accident. We can hold whoever held that social party responsible. The difference between the social establishment and the business establishment is on the social side, it only applies to minors. It doesn't apply to someone who was of age. So your fraternity brother who's 22 years old and gets drunk and gets into an accident, the fraternity can't be held liable for that. But they will be held liable for the 18-year-old freshman who got intoxicated and got into an accident. And the same would hold true if you had a house party. And again, if you had a house party and you served liquor and there were minors there and you didn't check and you served the liquor to the minors and the minor gets into an accident, as the homeowner, you're going to be responsible, and that's going to fall under your homeowner's insurance policy. And a lot of that, and this is just in the whole scope of third-party liability, anytime we have any type of claim, we always look to whether there's third-party liability to expand the base of insurance compensation that may be available. It's not happens in every case, but these dram shop cases and the social drinking cases, it can happen, and it's something that we always have to be aware of and look to. So we don't stop at the person who caused the accident. We do trace that back to see where that liquor came from in the first place and if there's potential third-party liability.
So this isn't just everything's thrown on whoever served the alcohol. The person who was drunk driving as well, that person is still held with liability. They're not off the hook just because it's a big organization.
They're not off the hook, but the problem you have, like in the situation with the minor's not going to have insurance or probably any wherewithal in terms of compensating the injured party unless they came under their parents' homeowner's policy or something like that. So they're never off the hook. So the original liability tortfeasor, if you will, is never off the hook.
So this is something interesting because I can actually speak on this because I was the house manager of a fraternity and we would host parties and we had a risk management team. We basically split it up to every 10 brothers. There's one brother who's on watch and we'd rotate and we would hire the police. The local police would come and we would have them card people who came in. Sure. So liability was put on the police because we paid them as an organization because it technically is a company. So just so people who know, it's not just a crapshoot and anything can happen. There are ways to protect yourself against these. And of course, even though you're just a plaintiff's lawyer, you don't want to like dry up all your cases, it is important to know that we don't condone it and we don't want this to happen. And we would wish that the laws and the way that people would try to prevent this. Because you mentioned that some policies that like larger corporations will have in terms of like training. And is that somewhere you look kind of like, all right, I notice you have training, but it's still inadequate, and that can still hold liability. So even if you have training, it might not be enough.
Sure. Yeah. A lot of people have policy and procedure manuals, but then they never train their people.
Just having the manual isn't
enough. Just having the manual is not going to be enough. And that's why when we do discovery in these kind of cases, we get right down to the nitty-gritty in terms of, okay, you got policies and procedures. Okay, how many training classes do you have? Were these people trained? In the course of discovery, we can take the deposition of the bartender, for instance, and say, did you ever receive any training on how to properly card somebody or how to determine whether you thought a person was a minor or not? Or it's not so much training, like I mentioned before. Sometimes it's obvious when somebody's intoxicated, but you give a little heightened responsibility to the bartender behind the bar because they do that for a living. And they're the first ones that should be cutting people off.
Definitely.
Okay. When somebody asks for another drink and they say, "I'm sorry, sir, I think you've had enough for the night."
When I was bartending, they had a stipulation in the contract when we signed up to work there that if there was any cases brought against the bar off of something that we had done, we were liable for some of the money, like up to $4,000 for if they had a $20,000 fine. So that's just something that even you'll see they'll start to protect themselves against their own employees.
Yeah, because sometimes it doesn't turn into a liability issue from an accident point of view. I mean, it's against the law for you to serve liquor to a minor.
You could lose your license.
You can lose your license.
That's an even bigger problem that people don't think about is that that's the end of the business, and so it's going to be really hard to get that money if.
And I guess you always have to be worried because sometimes they may do an undercover sting operation on the bar just to see if you are serving.
I had that happen to me before too.
Yeah. So, and that's the issue. I mean, it's always an unfortunate situation, and usually a DUI accidents tend to be the more severe accidents that you have because it's a little more simple than somebody just doing something like I didn't stop at the stop sign or something like that. They're usually driving very fast, driving very erratically, and you tend to find that those wrecks are a lot more serious than the normal car accident that you have. And it does also allow, when we have those kind of accidents, we can also seek punitive damages against the driver and potentially against the third-party liability person.
So what kind of damages are you looking for in terms of that liability once it's proven? Like how far can you push it? Like what are they fully responsible for?
Well, they're totally responsible for everything, like in any tort case, for the medical bills and pain and suffering.
Lost wages,
if it's
even?
Lost wages, or if it could be a wrongful death case. But punitive damages are above and beyond that. Punitive damages are there to kind of punish the act. And the punitive damage could be whatever the jury wants to award. And they can be quite high. And again, usually the tort fees, or the original tort fees, are the person who hit the other car is not going to have the means to pay that punitive side, but the third-party liability establishment may. And that's the other reason why you look to the third-party establishment, if you can, to prove liability against them, because, again, it opens that compensation pile. And we want to make sure that we search and get the best compensation we can for our clients and to look for all available sources for that compensation, so we never just stop at the car accident. We're going to go backwards.
So for the party that did get intoxicated, is there any part of the dram shop laws that actually protect them from a lawsuit if they've been overserved?
No.
Is it not on them?
No, it's always It's always on them, because then you see the intoxicated person doesn't have the mental capacity, usually at the time they're intoxicated, to know they had enough. I mean, sometimes it's up to that. That's why it's up to the bartender to know when they're going to cut them off. And a minor is never going to be off the hook because they know they were a minor at the time they took the liquor in the first place.
Kind of a lose-lose in a way.
Yeah. So everybody's going to be on the hook: the person who caused the accident and the potential third-party liability.
So ultimately, bars are liable for drunk drivers.
If they knowingly served a drunk drive. Now, if somebody, I mean, there can be the case, and I know people who sometimes get intoxicated with one or two drinks, and they don't look knowingly intoxicated. the bar would not be liable in that situation. It's only when you can prove that the bar establishment knowingly or should have known that the person was intoxicated and they should have stopped serving them. So they do have a defense if they can demonstrate, well, the person didn't look intoxicated. Yeah. And again, and the only way you're going to prove that is through the use of eyewitnesses or if there are surveillance cameras. Fortunately, most of these establishments do have surveillance cameras. So that's the first thing we do in these kind of cases is request that the surveillance videos be preserved and produced during discovery so we can see. Like in that one case I told you, we actually had the video showing serving a knowingly intoxicated person. That's the best way to prove it.
Okay. So video evidence is
video
really
is always best. People believe what they see.
Definitely.
Yeah.
Well, I think this basically answers all my questions I had about dram shop law. Is there anything else that you want to emphasize or add context to?
No, just again that whenever, hopefully, you're never in that situation, but know that that when we see that kind of situation, we're going to trace it back and try to find everything we can in terms of who may be ultimately liable for it.
So I lied. I did have one last question.
Sure.
And I'm just curious, in the context of just seeing how important dram shop law is, in your own experience with drunk driving cases, how many of them typically involve dram shop, where you push liability onto the bar, or is it more uncommon?
It's not all that common because, again, sometimes it's hard to prove and trace back.
If there's not a security camera, if there's
not a security camera,
good log of transactions, if they're doing cash and they just don't have a paper trail.
Yeah, we something you always look at, but sometimes you can't always prove. So it doesn't mean that we don't look for it, though.
So what if there's multiple bars? If they're hopping bar to bar to bar, does everyone liable or just the last one who overserved?
No, and that's an interesting question. In that situation, if at every establishment the person was knowingly intoxicated, you can hold every one of them responsible.
There was a hotel when we were out in Orlando. They had sister hotels nearby, and there was a guy who came in at the bar who was really drunk. He called up the other hotels and said, "This guy's going to come by. Do not serve him."
Yeah.
Little did he know those were the only bars open that late at night.
So yeah, but if you again, the whole question is if you can prove he was knowingly intoxicated,
that's all you need.
When they served him, it goes right down the chain. If there was multiple bars involved, then we would go after the multiple bars.
Definitely. Awesome. Well, thank you, David, so much for coming in and talking with us about it. Love the information. I hope it's helpful for all of you out there. And if you have any more questions or you want to hear more topics, please feel free to reach out to us.
Right.
Thank you, David.
Thank you.
Have a great day.
Bye.